Commission Chair, Christy Starr. This is an interesting fact pattern. It's an interesting moment in our state's history that brings us all here collectively today. There was something afoul about the 2020 election. I don't believe anyone who's going to speak to you today is going to argue that fact. The question before you in this moment is who is responsible for those errors and in what capacity are they responsible? You'll notice by looking at the charging documents that the commission staff, your staff, has charged my client and Ms. Gomez in their individual official capacity. And so this is not a circumstance in which the Pulaski County Board of Election Commissioners is the sole respondent here. These ladies are being charged as individuals and as a collective. And so in the normal legal discourse, if the Supreme Court members were still sitting in that chair, and this was some sort of civil action, this would be what we lawyers like to call joint and several liability, which basically means if a group of folks do a wrong, then that group is liable, and so are the individuals, members of that group, so liable in and of themselves. It's a very novel and creative legal argument, but it's not one that has any precedent in Arkansas law. I've served on boards and commissions for 20 years. I've been appointed to a board of commission by the last 4 governors of Arkansas. And I was always told that in Arkansas, if your commission makes an error, if your staff makes a mistake, you, sir, as the volunteer servant, is not liable. Your staff today seeks to change that. Now, that's not appropriate for a vast variety of reasons. First of all, under the law, with a commission, an individual cannot act for the body. It takes a vote of the body. And in the case of this specific board, the statute says 2 or more are required to act. And so to the extent that the body politic of the Pulaski County Board of Election Commissioners failed to act, or to the extent that their staff was negligent, or God forbid intentionally stole an election, you cannot hold the individual commissioners responsible. Because as an individual, there was not a doggone thing either one of these ladies could have done to stop this madness. Therefore, this case should not continue against them in their individual capacities, and the Pulaski County Board of Election Commissioners as a body politic should be substituted as the appropriate respondent. Now, when you look at this whole theory of joint and several liability, if the staff is correct, then we have argued in the alternative that you need to bring everyone before this body who had their hand on the steering wheel. And you'll hear testimony today that there were 2 forces that were allegedly in charge of this process. One was the Pulaski County Board of Election Commissioners that are duly authorized and duly appointed to be in charge of the election. But the other is Pulaski County Judge Barry High, who of his own constitutionally granted authority took control of the election staff and with them the election apparatus by an executive order in 2019. You'll see in that executive order, which is attached, that the judge said, I now take supervisory authority from you and the authority to hire, supervise, and fire professional staff. Now, many of you, I know you're resumes, you're managers. And I am a conservative, a proud conservative. One of the tenets of conservatism is individual responsibility. But it goes against the principles of conservatism to hold an individual liable for something they had no control over. And so if the judge took over the staff, the judge took over the infrastructure, then to have a complete litigation of these issues today, the judge should be sitting in this chair. But he's not, because the staff chose not to charge him. And so in Arkansas, in a civil action, am I about out of time?
You have about 10 seconds.
Okay, I'll take my 10 seconds. You need to bring all the parties together and charge them all. And if you don't, then you have to let everyone go. And so, finally, I just want to say that this should be dismissed because This law has been unconstitutionally applied to my client. Your staff had 7 months with this fact pattern, 7 months with these facts, 7 months with these witnesses. My client had 60 days or less, and that violates her rights and procedural due process. Thank you.
Thank you, Mr. Smith.